Cornell Law School. UCC, Article 2, Sales, Part 3, General Obligation and Construction of Contract. Paragraph 2301. General Obligations of Parties. Primary tabs. The obligation of the seller is to transfer and deliver, and that of the buyer is to accept and pay in accordance with the contract. Paragraph 2302. Unconscionable contract or clause. Primary tabs. 1. If the court as a matter of law finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. 2. When it is claimed or appears to the court that the contract or any clause thereof may be unconscionable, the parties shall be afforded a reasonable opportunity to present evidence as to its commercial setting, purpose and effect to aid the court in making the determination. Paragraph 2303. Allocation or division of risks. Primary tabs. Where this article allocates a risk or a burden as between the parties, unless otherwise agreed, the agreement may not only shift the allocation but may also divide the risk or burden. Paragraph 2304. Price payable in money, goods, realty, or otherwise. 1. The price can be made payable in money or otherwise. If it is payable in whole or in part in goods, each party is a seller of the goods which he is to transfer. 2. Even though all or part of the price is payable in an interest in realty, the transfer of the goods and the seller's obligations with reference to them are subject to this article, but not the transfer of the interest in realty or the transferor's obligations in connection therewith. Paragraph 2305. Open price term. 1. The parties, if they so intend, can conclude a contract for sale even though the price is not settled. In such a case, the price is a reasonable price at the time for delivery if A. Nothing is said as to price, or B. The price is left to be agreed by the parties and they fail to agree, or C. The price is to be fixed in terms of some agreed market or other standard as set or recorded by a third person or agency and it is not so set or recorded. 2. A price to be fixed by the seller or by the buyer means a price for him to fix in good faith. 3. When a price left to be fixed otherwise than by agreement of the parties fails to be fixed through fault of one party, the other may at his option treat the contract as cancelled or himself fix a reasonable price. 4. Where, however, the parties intend not to be bound unless the price be fixed or agreed and it is not fixed or agreed, there is no contract. In such a case, the buyer must return any goods already received, or if unable so to do must pay their reasonable value at the time of delivery, and the seller must return any portion of the price paid on account. Paragraph 2306. Output, requirements and exclusive dealings. 1. A term which measures the quantity by the output of the seller or the requirements of the buyer means such actual output or requirements as may occur in good faith, except that no quantity unreasonably disproportionate to any stated estimate or in the absence of a stated estimate to any normal or otherwise comparable prior output or requirements may be tendered or demanded. 2. A lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes, unless otherwise agreed, an obligation by the seller to use best efforts to supply the goods and by the buyer to use best efforts to promote their sale. Paragraph 2307. Delivery in single lot or several lots. Unless otherwise agreed, all goods called for by a contract for sale must be tendered in a single delivery, and payment is due only on such tender, but where the circumstances give either party the right to make or demand delivery in lot's price, if it can be apportioned, may be demanded for each lot. Paragraph 2308. Absence of specified place for delivery. Unless otherwise agreed, A. The place for delivery of goods is the seller's place of business, or if he has none, his residence, but B. In a contract for sale of identified goods which to the knowledge of the parties at the time of contracting are in some other place, that place is the place for their delivery, and C. Documents of title may be delivered through customary banking channels. Paragraph 309. Absence of specific time provisions. Notice of termination. 1. The time for shipment or delivery or any other action under a contract if not provided in this article or agreed upon shall be a reasonable time. 2. Where the contract provides for successive performances but is indefinite in duration and is valid for a reasonable time, but unless otherwise agreed may be terminated at any time by either party. 3. Termination of a contract by one party except on the happening of an agreed event requires that reasonable notification be received by the other party, and an agreement dispensing with notification is invalid if its operation would be unconscionable. Paragraph 310. Open time for payment or running of credit. Authority to ship under reservation. Unless otherwise agreed, A. Payment is due at the time and place at which the buyer is to receive the goods, even though the place of shipment is the place of delivery, and B. If the seller is authorized to send the goods, he may ship them under reservation, and may tender the documents of title, but the buyer may inspect the goods after their arrival before payment is due unless such inspection is inconsistent with the terms of the contract, Section 2513, and C. If delivery is authorized and made by way of documents of title otherwise than by subsection B, then payment is due at the time and place at which the buyer is to receive the documents, regardless of where the goods are to be received, and D. Where the seller is required or authorized to ship the goods on credit, the credit period runs from the time of shipment, but post-dating the invoice or delaying its dispatch will correspondingly delay the starting of the credit period. Paragraph 311. Options and cooperation respecting performance. 1. An agreement for sale which is otherwise sufficiently definite, subsection 3 of Section 204, to be a contract is not made invalid by the fact that it leaves particulars of performance to be specified by one of the parties. Any such specification must be made in good faith and within limits set by commercial reasonableness. 2. Unless otherwise agreed, specifications relating to assortment of the goods are at the buyer's option, and except as otherwise provided in subsections 1, C, and 3 of Section 2319, specifications or arrangements relating to shipment are at the seller's option. 3. Where such specification would materially affect the other party's performance but is not seasonably made, or where one party's cooperation is necessary to the agreed performance of the other but is not seasonably forthcoming, the other party, in addition to all other remedies, A. is excused for any resulting delay in his own performance, and B. may also either proceed to perform in any reasonable manner, or after the time for a material part of his own performance treat the failure to specify or to cooperate as a breach by failure to deliver or accept the goods. Paragraph 312. Warranty of title and against infringement. Buyer's obligation against infringement. 1. Subject to subsection 2. There is in a contract for sale a warranty by the seller that A. the title conveyed shall be good, and its transfer rightful, and B. the goods shall be delivered free from any security, interest, or other lien or encumbrance of which the buyer at the time of contracting has no knowledge. 2. A warranty under subsection 1 will be excluded or modified only by specific language or by circumstances which give the buyer reason to know that the person selling does not claim title in himself, or that he is purporting to sell only such right or title as he or a third person may have. 3. Unless otherwise agreed, the seller who is a merchant regularly dealing in goods of the kind warrants that the goods shall be delivered free of the rightful claim of any third person by way of infringement or the like, but a buyer furnishes specifications to the seller must hold the seller harmless against any such claim which arises out of compliance with the specifications. Paragraph 313. Express warranties by affirmation, promise, description, sample. 1. Express warranties by the seller are created as follows. A. Any affirmation of fact or promise made by the seller to the buyer which relates to the goods and becomes part of the basis of the bargain creates an express warranty that the goods shall conform to the affirmation or promise. B. Any description of the goods which is made part of the basis of the bargain creates an express warranty that the goods shall conform to the description. C. Any sample or model which is made part of the basis of the bargain creates an express warranty that the whole of the goods shall conform to the sample or model. 2. It is not necessary to the creation of an express warranty that the seller use formal words such as warrant or guarantee or that he have a specific intention to make a warranty, but an affirmation merely of the value of the goods or a statement purporting to be merely the seller's opinion or commendation of the goods does not create a warranty. Paragraph 314. Implied warranty, merchantability, usage of trade. 1. Unless excluded or modified, Section 316, a warranty that the goods shall be merchantable is implied in a contract for their sale if the seller is a merchant with respect to goods of that kind. Under this section, the serving for value of food or drink to be consumed either on the premises or elsewhere is a sale. 2. Goods to be merchantable must be at least such as A. Pass without objection in the trade under the contract's description, and B. In the case of fungible goods, are of fair average quality within the description, and C. Are fit for the ordinary purposes for which such goods are used, and D. Run within the variations permitted by the agreement, of even kind, quality and quantity within each unit and among all units involved, and E. Are adequately contained, packaged, and labeled as the agreement may require, and F. Conform to the promise or affirmations of fact made on the container or label if any. 3. Unless excluded or modified, Section 316, other implied warranties may arise from course of dealing or usage of trade.